Quickly cutting across to Hamburg, and that verdict on the Italian Marines is expected. Let's listen in.
Over the dispute. Considering that Article 23, paragraph 1 of the Convention reads as follows: when a dispute arises between states parties concerning the interpretation and application of this Convention, the parties to the dispute shall proceed expeditiously to an exchange of views regarding a settlement by negotiation or other peaceful means. Considering that both parties agree that an extensive exchange of views has taken place and that this did not lead to an agreement between the parties regarding the settlement of the dispute by negotiation, the Tribunal is of the view that the requirements of Article 23, paragraph 1 of the Convention are satisfied. Considering that Article 295 of the Convention provides any dispute between states parties concerning the interpretation or application of this Convention may be submitted to the proceedings provided for in this section only after local remedies have been exhausted where this is required by international law. Considering that India maintains that Italy should have exhausted the local remedies available before the Indian courts and that the Annex 7 Tribunal can only exercise its jurisdiction and rule on the claims of Italy once all remedies available to the two accused have been exhausted. Considering that Italy states that the rights claimed by Italy are rights of Italy, rights which have been directly infringed by India, and that no question of exhaustion remedies arises. Considering that, in the view of the Tribunal, since the very nature of the dispute concerns the exercise of jurisdiction over the Enrica Lexi incident, the issue of exhaustion of local remedies should not be addressed in the provisional measures phase. Considering that India states that Italy's initiative constitutes an abuse of legal process, an abuse which India reserved its right in due course to draw the attention of the future Annex 7 Tribunal in accordance with Article 294 of the Convention. Considering that India states that Italy chose to seize the Indian courts and now turns away from them and seeks to remove the case to the international level. Considering that Italy, in response to this allegation, states that it is Italy's right to start proceedings under UNCLOS in connection to a dispute which India's own Supreme Court accurately characterizes as concerning the interpretation of UNCLOS provisions. Considering that Italy also maintains that Italy objected promptly to the Indian domestic proceedings. Considering that the Tribunal is of the view that Article 290 of the Convention applies independently of any other procedures that may have been instituted at the domestic level, and that Italy is therefore entitled to have recourse to the procedures established in that article, and that if proceedings are instituted at domestic level, that does not deprive a state of recourse to international proceedings. Considering that Article 290, paragraph 5 of the Convention has to be read in conjunction with Article 290, paragraph 1 of the Convention. Considering that under Article 290, paragraph 1 of the Convention, that the Tribunal may prescribe any provisional measures which it considers appropriate under the circumstances to preserve the respective rights of the parties to the dispute. Considering that in this regard Italy invokes its rights under the Convention and customary international law, in particular Italy's right of exclusive jurisdiction over the Enrica Lexi incident, including in relation to the exercise of criminal jurisdiction over the Marines, and B, Italy's right in relation to its own immunity and immunity of its officials. Considering that Italy argues that as the flag state it has the right to exercise exclusive jurisdiction over vessels flying its flag, as set out in Article 92, paragraph 1 of the Convention, which is applicable to the exclusive economic zone by virtue of Article 58, paragraph 2 of the Convention, and that none of the exceptions provided for in the Convention or in any other treaties applies to the present instance. Considering that Italy states that it promptly asserted its jurisdiction over the Enrico Lexi, over the incident and over the Enrico Lexi crew, including the Italian Marines, and subsequently attempted to exercise and defend its exclusive jurisdiction. Considering that India argues that since 2 of its unarmed fishermen were killed, the right to inquire, investigate, and to try the accused is a fundamental right of India. Considering that India maintains that under the Convention, immunity from the jurisdiction of any state other than the flag state is available only to warships and government ships operated for non-commercial purposes, and notes that no bilateral agreement exists between India and Italy for granting such immunity to armed forces personnel of Italy. Considering that India claims that its right to continue the judicial process that has been set in motion should be preserved. Considering that in provisional measures proceedings, the Tribunal is not called upon to settle the claims of the parties in respect of the rights and obligations in dispute, and to establish definitively the existence of the rights which they each seek to protect. Considering that before prescribing provisional measures, the Tribunal does not need to concern itself with the competing claims of the parties, and that it needs only to satisfy itself that the rights which Italy and India claim and seek to protect are at least plausible. Considering that the Tribunal finds that both parties have sufficiently demonstrated that the rights they seek to protect regarding the Enrico Lexi incident are plausible. Considering that pursuant to Article 290, paragraph 5 of the Convention, the Tribunal may prescribe, modify, or revoke provisional measures if it considers that the urgency of the situation so requires. Considering that Article 290, paragraph 1 of the Convention stipulates inter alia that the Tribunal may prescribe any provisional measures which it considers appropriate under the circumstances to preserve the respective rights of the parties, which implies that there is a real and imminent risk that irreparable prejudice could be caused to the rights of the parties to the dispute pending such time when the Annex 7 Arbitral Tribunal to which the dispute has been submitted is in a position to modify, revoke, or affirm the provisional measures. Considering that, as stated in its request, Italy seeks the prescription of provisional measures on the following 2 principal grounds. A. The serious and irreversible prejudice that will be caused to its rights under UNCLOS if Indian jurisdiction continues to be exercised over the Enrico Lexi incident. And B. The serious and irreversible prejudice to Italy's rights if its Marines continue to be subjected to Indian jurisdiction, in particular to measures restricting their liberty and movement, notwithstanding the commencement of international arbitration, and that irreparable consequences for personal health and well-being that such restriction will or are likely to cause. Considering that Italy further contends in the request that India's decision to persist in exercising jurisdiction, notwithstanding the commencement of international proceedings under UNCLOS, creates a clear risk of prejudice to the carrying out of future decisions of the Annex 7 Arbitral Tribunal. Considering that Italy also points out that if India preserves in the exercise of jurisdiction over proceedings in a criminal trial while the dispute is still pending, all risk of irreparable prejudice will be on Italy's side. Considering that India maintains that it also possesses fundamental rights that would be prejudiced if the Tribunal were to accede to Italy's submissions, and that its rights at stake are even more important, and that in this case, what is irreparable are not the rights that Italy claims will be prejudiced, but rather the fact that the 2 Indian fishermen are dead. Considering that with regard to the first ground on which Italy seeks provisional measures, India contends that this is pure, unwarranted speculation without a shred of evidence to back it up, and points out in this connection that the conduct of the Indian courts in the matter over the past 3 years has been beyond reproach, and that India's Supreme Court has gone to considerable lengths to preserve Italy's and Marines' rights, including the right to raise any issue of jurisdiction and immunity before the Special Court. Considering that with reference to Italy's second ground for seeking provisional measures, India further contends that the well-being and humanitarian considerations in favor of persons accused of serious crime have to be balanced with that of victims of the crime, and that it is a generally accepted principle that the latter should prevail in case of conflict. Considering that Italy states that under Article 290, paragraph 1 of the Convention, the rights which the Annex 7 Tribunal has not yet adjudged are to be preserved, that Italy cannot preserve those rights if India continues to exercise jurisdiction, and that Italy points out that in its written observations, India has left no doubt as to its determination to put the Marines on trial, and that, as observed by Italy's agent, India has seemed to have already decided the outcome of that trial. Considering that Italy further states that for all intents and purposes, therefore, the criminal trial which India now insists should commence as soon as possible would be a fait accompli, depriving the Annex 7 Tribunal of any effect if it decides in Italy's favor. Considering that Italy contends that in the circumstances where irreparable harm is being suffered by Italy through each and every exercise of jurisdiction, urgency is demonstrated by the fact that the exercise of jurisdiction by India is certain and ongoing. Considering that Italy points out that urgency is both humanitarian and legal, that the status quo in relation to the Marines is one where their rights and Italy's rights are suffering irreparable damage on a daily basis, and that every additional day in which a person is deprived of these rights must be regarded as one day too many. Considering that India contends that neither the first nor the second Italian submission fulfills either the aggravated urgency standard resulting from Annex Article 290, paragraph 5 of UNCLOS, or even the basic standard of urgency. Considering that with reference to the first Italian submission, India states that when the facts are placed in their proper context, they show that there is absolutely no situation of urgency that justifies the tribunal issuing an order restraining India from continuing to take judicial or administrative measures, measures that it has always carried out lawfully and with absolute fairness to Italy and the two Marines, and to exercise any other form of jurisdiction. Considering that with reference to the second Italian submission, India states that the situation of either of the accused persons cannot justify any prejudgment by this tribunal concerning their conditions of living. Considering that India points out in this regard that in the case of Sergeant Latorre, new extensions for his stay in Italy are not to be excluded, if necessary, on humanitarian grounds, and that given the renewable 6 months leave granted by the Supreme Court on 13 July 2015, Italy is ill-advised to invoke any urgency in this matter. Considering that India further points out that in the case of Sergeant Gironi, the urgency of authorizing him to go back and to go back to and stay in Italy is valid by his own behavior, namely by the fact that in the proceedings before the Supreme Court of 16 December 2014, he formally withdrew his interim